My name is Vishnu Gopal TV. I am a legal intern at LEXIS and Company. I am from Cooperative School of Law, Kerala. I am a third year student pursuing BBA LLB Honors. So today's topic for this video is mistake under the Indian Contract Act 1872. So the purpose of this video is to analyze the concept of mistake dealt under the Indian Contract Act 1872. So we know that mistake can be defined as an incorrect idea or opinion about something. So section 20, 21 and 22 of the Indian Contract Act 1872 deals with the concept of mistake. So we know that mistake are of mainly two types, mistake of fact and mistake of law. So there is a need to look into the concept of mistake of law as well as mistake of fact. So first we can analyze the concept of mistake of law, which means the ignorance of law is not an excuse. So it means ignorance of Indian law is not an excuse. But in case of mistake of foreign law, it is being treated as a mistake of fact and agreement in such a case is void. So now there is a need to look into the concept of mistake of fact. So we know that mistake of fact are of mainly two types, bilateral mistake and unilateral mistake. So each of these, that is bilateral mistake as well as unilateral mistake, has to be analyzed. So first we can look into the concept of bilateral mistake, and bilateral mistake means both the parties to the agreement are under the mistake as to the matter of fact, then it is known as bilateral mistake. So bilateral mistake are of mainly two types. They are common mistake and mutual mistake. So common mistake means if the promisor and the promisee are both under or both mistaken about the existence of fact, that is fundamental as for the basis of the contract, then it is known as common mistake, and here the contract is void. So common mistake may be as to subject matter of the contract or as to the possibility of performing the contract. Common mistake as to the subject matter covers common mistake as to the existence of subject matter, common mistake as to the title of subject matter, common mistake as to the quality of subject matter, common mistake as to the quantity of subject matter, as well as common mistake as to the price of subject matter. So common mistake as to the possibility of performing the contract means if both the parties believe that the contract is capable for performance but in fact not capable for performing or performance, the agreement is void. So the common mistake as to the possibility of performance or performing the contract are of mainly two types. They are physical impossibility and legal impossibility. So that's about that. So now there is a need to look into the concept of mutual mistake. So we know that mutual mistake means if the promisor and the promisee misunderstands each other's intention, though they neither realize that his or her promise misunderstood by the other person. So that's about the concept of mutual mistake. Now the concept that has to be analyzed is unilateral mistake. So unilateral mistake means when only one party to the contract is under the mistake, then it is known as unilateral mistake. So the two exceptions to the rule that unilateral mistake is not void or voidable are mistake as to the person contracted with and mistake as to the nature of contract. So mistake as to the person contracted with means if X, a person intends to contract with Y, another person, but by mistake entered into a contract with N, here in this or here the contract is void if N has, or if N intends to, or if N knows that the X has intended to enter into a contract with Y. So if X knows that, or if N knows that X has intended to enter into a contract with Y, then such a contract is void. So mistake as to the nature of contract means if a person executes a document in ignorance of its character, he can avoid his obligation by pleading the doctrine of non est factum. So that's about unilateral mistake. We have analyzed about bilateral mistake, as well as we have looked into the concept of mistake of fact as well as mistake of law in a detailed manner. So that's all about the topic. So you can like, subscribe and comment on my video, and do like and subscribe our YouTube channel Let's Click. Please give me a feedback regarding this video, and if you have any questions relating to this video, you may please mention that question in the comment box and I will be replying as soon as possible. This video does not solicit any types of promotion or advertisement as per the guidelines of Bar Council of India, and the sole purpose of this video is for educational purposes only. So by saying these words, I'm concluding. Thank you.